We'll call this meeting to order. It's meeting number 11 of the Standing Committee on Justice and Human Rights, and we're dealing with Bill C-10, an act to enact the Justice of Victims Terrorist Act to amend the State Immunity Act, the Criminal Code, the Controlled Drugs and Substances Act, Corrections and Conditional Release Act, the Youth Criminal Justice Act, the Immigration and Refugee Protection Act, and other acts. It's obviously very comprehensive, and time is of the essence because it is a large bill, so we'll get started here on time. So that we understand, Clause 1 is postponed pursuant to Standing Order 75-1, and we'll come back to Clause 1. So we move right to Clause 2, and my understanding is that we do have an amendment being proposed by the NDP.
Yes, Mr. Chair, we have a proposal in Clause 2 that Clause 2 be amended. I think it's been circulated that Clause 2 be amended by adding after line 14, and this is in relation to the entire Bill C-10, that the Act be amended by adding 3.1 within 3 years after this Act comes into force, a comprehensive review of the provisions and operations of this Act, including a cost-benefit analysis of its implementation that incorporates the cost to the federal government, and to the extent possible, the cost to provincial and territorial governments must be undertaken by a committee of this House or both Houses of Parliament that may be designated or established for that purpose. If I may speak to it, Mr. Chair, this is an amendment, as we all know. This is a most controversial piece of legislation. There are strong opinions on both sides of this. We've heard witnesses talk about how, first of all, this is going to be an extremely costly bill in that the increase in the number of people who will be put into prison as a result of this will have a significant cost in corrections for both provincial and federal federal and territorial, provincial agencies who have bear the costs of having people in prison for less than 2 years, because of the nature of our division of correctional responsibility in Canada, but also, of course, the human cost. There are many who appeared before us and many in the public who have said that this is in fact a backward step. This will not reduce crime. The overall effect of these provisions, and I say this on the clear understanding that we support some aspects of it. We in fact moved in the House of Commons on 2 occasions to take the sexual assault, the new sexual assault provisions out of this bill and have them dealt with separately and fast-tracked to the House. But the overall impact of this bill, particularly those which are going to be adopting a more punitive approach, which sees more people in prison, the effect of which has been described as being extremely detrimental to society. There will be, as some of our witnesses said, in fact, more crime, more victims, more social dislocation, putting enormously increased numbers of people in prison for petty, I guess it's petty trafficking you'd call it, but petty dealing of marijuana and cannabis products, for example. This is going to lead to creating more criminals, more social dislocation, more people unable to get out of that and get into a rehabilitative life, which is one of the principal aims of the correction system. The judges in dealing with sentencing, for example, talk about the protection of society, and the question being how best to achieve that. And we have very highly trained and might I say expensive judges who are given the task of determining how best to achieve that on an individual case. So the principles of sentencing as a protection of the public is that best achieved by rehabilitating the offender or by punishing that offender and for a lengthy period of time. That's what the principles of sentencing are all about. We had the Minister of Justice in the House yesterday telling the opposition that they should respect the judiciary, that they should not play politics with the judiciary, that they should respect the judiciary. Well, the respect for the judiciary recognizes that the judiciary has a responsibility and role in our society of crafting a sentence that does the best job in terms of the protection of the public. And so this bill, many feel, does not respect the judiciary, the people who are given the task by our society to determine how to deal with each individual offender. It's called judicial discretion, but it's not discretion in an arbitrary sense. It's a discretion that allows the application of the law to each individual case and the consideration of all of the factors that go into a proper and fit sentence. If you ask everybody in this country, do you think we need to have a justice system where the punishment fits the crime? I doubt very much if you'll have anybody objecting to that. But that doesn't justify a regime where the legislature is setting out arbitrary sentences, mandatory minimums for swaths and swaths of crimes that ought to be dealt with by the application of judicial principles of sentencing that ensures the protection of the public. When we have experts in criminology, experts in corrections, experts in an understanding of the law professors, etc., telling us that aspects of this bill will lead to more crime and lead to more victims of crime, then we have a serious problem. So, we're not being naive here. We know that we can count. We know the numbers. We expect, I suppose, that much of, if not all of this bill, and maybe there are some amendments, will be accepted. We do live in hope. Our job is to try to be persuasive, and we will be trying to do that. But I think what we need to recognize is that this bill, comprehensive as it is in nature, needs to have a review of the success or failure of its provisions in terms of doing what the government says that it's going to do. We do know that the costs are there. The provinces have told us that. Quebec Attorney General was here telling us about that. We've had extensive media coverage of other provinces concerned about the cost and the fact that it's being downloaded to them. Obviously, there's going to be political implications for that, but from a Government of Canada point of view in the House of Commons, we want to see a comprehensive review as to how this has operated. So the provision here, it's inserted very early in the Act, and it's not related to the Justice for Victims of Terrorism Act, but we were advised by the legislative draftspersons that this was an appropriate place to insert it early in the bill so that it could receive consideration up front. We believe that this bill is far overreaching. It adopts a punitive approach rather than a rehabilitative approach, and unfortunately, for those who are concerned about the costs of crime to victims, this bill and the consequences of this bill will lead to greater criminalization of our society, and indeed more victims who will be suffering as a result, because we'll be creating more criminals, whether it be the provisions of the Youth Criminal Justice Act that are being proposed here, whether it will be the lengthy period of time that people will be incarcerated prior to trial, who might otherwise not be exposed to that level of the criminal element that are in our prisons, that will be hardened and be less likely to be able to be rehabilitated. I mean, I could go on and on. There's provisions here that are mean-spirited when it comes to our pardon system, taking away the notion of pardon and changing it to sentence suspension, record suspension. Sounds to me, you know, and I practiced criminal law for part of my career, but I practiced law for 30 years. When you talk to the ordinary person about record suspension, that's no different in their mind than suspended sentence. Doesn't really have the same impact as a pardon. Well, I got a pardon for that offense which I committed when I was 18 or 19 or 20 or 21. Yes, I've been pardoned for that. I've proven to the parole board, I've proven to society that I am rehabilitated, I have been rehabilitated, I have received a pardon. That to me is a meaningful expression of society's recognition of someone having rehabilitated themselves. And to take away that notion that someone can redeem themselves. Redemption, you know, is a very significant value in our society. It's part of Christian heritage, it's part of all religious heritage, that someone who has offended can be redeemed somewhere along the way and demonstrate that they are no longer a threat to society. Well, the pardon encapsulates that. Say, well, no, we're not going to, we're just going to suspend your record. Well, you know, that has a very different aspect. That's a small example, but an important one as to how this legislation fails our society, fails our system. You know, something must be happening right. I mean, we know obviously there are victims of crime, and each and every victim of crime deserves our understanding and our compassion, and in fact probably deserves far more than they get in terms of criminal injuries compensation, which we had a half-decent system 10 or 15 years ago. It's been gutted mostly across the province since the federal government stopped supporting it. But there was recognition for victims on the criminal injuries compensation side, which has dissipated. And you can't just talk about how we support victims. And we believe in victims. We do believe that victims need to be included in the system, and you'll see when we talk about this bill that there is that we support the involvement of victims in the parole process. We support victims having greater knowledge of where the offender who perpetrated the crime against them is located within the system, what discipline they're being subjected to, and other things. So there are aspects of this bill as we proceed clause by clause. And Mr. Chair, I hope you'll indulge me a little bit. I'm just giving a little bit of an overview here of our concerns about this bill. But we do see aspects of this bill, the particular individual points that are improvements, but the bill as a whole needs to be reevaluated after a period of implementation and we were proposing 3 years, because we think it's a significant shift in how we approach criminal law and corrections in Canada, and it's one that we have grave concerns is going to lead to greater criminality, a greater attack on our society by separating the notion of rehabilitation as a means of public safety. We're not talking about rehabilitation because we want to treat criminals in an easy manner. We're talking about rehabilitation for the benefit of society, that someone who can be saved from a life of crime or rehabilitated back into society be given an opportunity to do that. And that's for the purpose of public safety, for making our streets safer. We've got a name here, the Safe Streets and Communities Act. Well, you know, this government has a habit of some cases laughable euphemisms for some of the bills that they brought through, particularly in the criminal justice area. But the reality is that we've received significant evidence from experts, and when I say experts, people with experience and knowledge and statistics and significant academic records, studies, demonstrations that prove that there's a
point of order, Mr. Harris.
Yes, Mr. Chair. We've been here for 15 minutes now, and we haven't got to a clause, or at least any kind of substantive part of a clause. And I must have missed the memo about a filibuster before the meeting started. But Mr. Harris has been here long enough to recognize that this particular clause is moot. Any committee of the House and the House itself can move a motion at any time to do exactly what he wants. And within 3 years, the numbers, as he said, are going to be exactly the same as they are today. So this clause is not necessary, as any committee can take this study on at any time. They can move a motion. They are the master of their own destiny. So if his intention is to filibuster, I wish I would have got the memo last night because I could have got an extra 5 hours sleep. It would certainly be helpful to move on to something more substantive.
Thank you.
I don't believe it's a point of order. It sounds like argument to me. If he wants to argue against
debate,
it,
so
I don't intend to take all day. I say, Mr. Jean, but I do want to emphasize that as a part of the Act, it's an important piece of important clause to say that this legislation must be reevaluated after a period of implementation of 3 years. Yes, any committee can do it, but when you have a legislative mandate to do this, then it's taken as a requirement, and it can't be undone without changing legislation, that which is a serious thing, as the member knows. You know, we have. I suppose the point of order was to set me off my track, which is unfortunate because it stops me from being concise. You know, I have to go back. I'm not going to start. I'm not going to start all over again. But I want to emphasize, Mr. This is not an intention whatsoever to filibuster this, and you'll see that very shortly when we start moving some of the recommendations, some of the clauses in a block, because we do believe there are some aspects of this bill that should get speedy attention. But I think it's very, very clear that there's a significant difference between the approach taken in this legislation and the approach that seems to have done a lot of good in Canada. We have a decreasing crime rate. We do have serious problems in our cities with guns and gangs. There's no question about that. And we do have crimes that go undetected and unpunished in some cases. But that's a question of law enforcement. And in this particular case, we're talking here about what do you do with someone who is before the courts. We believe we've heard significant objections to this. I myself have received in excess of 10,000. I think we might be up to 15,000 letters to date. The same copies have been sent to other members and to the Minister of Justice and the Prime Minister, objecting to the approach being taken by this bill. So it's a significant matter of public debate, and I believe that this approach, which this government is trying, some grand experiment, let's see if we can fix this by doing here what was done 20 years ago in the States and failed. Let's roll back the clock and pretend we're in 1980 somewhere in the United States, and we'll be tough on criminals and see if it works. Well, it didn't work in the United States if incarcerating more people was leading to a safer society. Well, the United States would be the safest country in the world. We all know that that's not the case because of the crime rates in the United States are through the roof. We've seen in Canada, on the other hand, we talk about safe streets and safe communities. The reality is, despite all of the publicity that's given to violent crime and certain types of crime within Canada, when Canadians asked in polling as to how safe they feel in their communities and their homes, 93%, and this is not some flimsy, one-question poll, and serious polls demonstrate that 93% of Canadians actually feel safe. So it's we've got a situation here where this bill is out of step and out of touch with history, with the experience of those who understand the field, and in some cases with common sense. It's punitive in nature and ought to and will lead, as many suggest, to greater lack of safety and not safer communities. So, having said that, Mr. Chair, I move this amendment for your consideration, so that when this bill passes, we will all know that it's going to be reviewed on a comprehensive basis within 3 years.
Thank you, Mr. Harris. And I was remiss when I started here to try and get us going early that I neglected to indicate to the committee that we have 2 legislative clerks with us here today to help us, and officials from both Justice and Public Safety if anyone has questions. So, having said that, Mr. Jean, you're next on the list.
Actually, Mr. Chair, I made my point in my point of order.
Okay. Ms. Boyvan?
Merci. Peut-être pour juste
Perhaps to just add something, because we are at the beginning, we're just starting this in-depth study clause by clause of the bill. We talk about 9 important pieces of legislation in this country, and we have a great many questions to ask ourselves about the form and the extent of this bill. But if there is an amendment that needs to be adopted in terms of principle, and I have legal experience going back over 25 years at the Bar of Quebec, this motion would help deal with some of our concerns about this omnibus bill, and it would help people like me who are very concerned with the legal side of things. Our role is that of legislator, and the decisions which we take here today will have a very great impact on the future. There will be lawyers who will be looking to find holes or loopholes, and those around the table who have legal experience will know what I am talking about. There's a possibility of slipping through the cracks of the system, and therefore we are proposing motions, and this particular motion does not change the content of the bill at all. It just gives us the assurance, even as Mr. Jean has said, rather, that this could be reviewed by any committee, but if this particular motion is adopted, if the bill passes the House and the Senate, we will be assured that there will be a review after 3 years, whether it's a committee of the House or a joint committee. But we want to see what the costs are for the federal government, and if possible the provinces and territories. So whether it is the Canadian Bar, the Quebec Bar, various points have been brought up which cast some light on this legal reform, and the Quebec Bar's last edition, November 2011, referring to Bill C-10, they talk about a legal reform which is not well founded. So it's not just a question of concern for defense lawyers, but also for prosecutors, for all people involved in the justice system. As a result of this bill, some people who could be rehabilitated will be sent to prison, and a specialist from the Quebec Bar has also analyzed these questions, and he said that this omnibus bill causes concern among criminal lawyers. And I'm saying this is not just defense lawyers, but also prosecutors, because these new measures will provide for harsher sentences for people involved in drug or sexual offenses. But one of my concerns is, when you see the sort of amendment we're bringing in this morning, we have the impression as legislators, new members of Parliament, and this is the 41st legislator, some people may have heard evidence in previous committees, in previous legislatures, but many of us here are new, so we have not heard these former committees. But we have been sent here. We have been sent here to work, to do this very important work, to make sure that the legislation which we adopt achieves the ends sought. So legally speaking, these reforms are not really required. It's more a question of an ideological approach. And I've heard this from the few witnesses we have heard. We have not had a great deal of time for addressing questions to them, because, as Mr. Harris has said, there are parts of this omnibus bill which we agree with. So when there are people who are in agreement, the majority on either side is in favor of certain aspects, then we should make sure that these parts can go ahead and be applied as soon as possible. But we have conducted an in-depth study that with some parts of the legislation do not pose a problem, but that is not true for the entire bill. Often at the present time, judges can exercise discretion and not send someone to prison if they feel that other options are more appropriate. So, and this works very well. There may be some cases where there have been problems, but it should be possible to solve these occasional problems rather than act in the way that is being proposed. And in the case of pardons, you can say, well, we want these people to serve their sentences, but once they've paid their debt to society, not only are they told that penalties are being increased, but you are not going to get a chance to get back into society, to be reintegrated into society. So there's some very fundamental changes here, and we see this throughout the legislation. And there will be challenges before the courts. The Quebec Bar is sure that there will be more complaints, more challenges, because of the unfortunate effects of some of the penalties assigned. Otherwise, some points could be settled by negotiation. There may be constitutional problems with regard to this legislation. So with this bill, C-10, we have seen the example of the United States and Great Britain and their imprisonment policies, and we see they have not achieved their aims to reduce crime. The question of safe streets, I would say it is legislation which leads to a lack of safety, because this omnibus bill is so massive. I am very concerned as someone with legal expertise, with a member from Gatineau. I think that we have a system which operates quite well, and there have been previous studies of 3 of the 9 acts implicated in this bill. And many experts came and gave evidence before committees. But the government has not listened to them. They do not seem to have benefited from their suggestions. So we have this system which, what is being proposed really does not reflect the honor of what we should be doing as a committee. So I hope that the amendment as moved to the bill, that it will be possible to accept this motion so the bill can be re-examined in 3 years, because we may find ourselves with challenges before the courts rather than negotiations. This is not going to serve the victims either, and I really haven't seen anything that really is in line with what the victims who have come to speak to us have said either. So I think that what is being done here, perhaps the government may be being sincere, and I think that the other members should accept this motion. It's a wise motion, and it respects the nature of the legislation.
I'll call the vote. Those in favor? Those opposed? Fails. We'll now move to Liberal number 1 amendment. Mr. Kotler, I believe you have an amendment.
Yes, Mr. Chairman, thank you. Let me explain the amendment, because we support the objective of this legislation, and the purpose of this legislation is to provide for the first time a civil remedy for victims of terror against their terrorist perpetrators. Those terrorist perpetrators can be either the state sponsor of terrorism itself, that is to say, it could, for example, in the case of Libya, be not only an agent who is a listed entity in Canada who carries out the terrorist act, but it could be the state itself that perpetrates it. Or let us say, in the case of Iran, the terrorist act may not only be carried out by a listed entity in Canada that is its proxy, for example, Hamas or Hezbollah, but it could be carried out directly by the state itself, Iran. Now, this legislation, as I say, in terms of its overall objective, we support it, because what it does is that it amends the State Immunity Act, which thus far has shielded states or their agents from any civil liability such that no victim, no Canadian victim of such an act of terror could initiate a remedy in a Canadian court. And in effect, we had this anomalous, if not, legally and morally absurd situation where, by reason of the State Immunity Act shielding the foreign perpetrator of terrorism, it prefers the foreign perpetrator of terrorism, as it were, in its consequences, over the Canadian victim that is seeking a remedy. And so the purpose of this legislation to effectively give a remedy to Canadian victims is something that we support. I might add, Mr. Chairman, that we have also the anomalous situation where if there is a breach of contract by that foreign state, then a remedy lies. But if it's a terrorist act that causes damages, a remedy does not lie. And surely a victim of terror is deserving of a remedy no less than a person who suffers damages by reason of a breach of contract. Now, the purpose of this specific amendment, Mr. Chairman, is because it does not, the legislation as now drafted, with which we agree, does not catch the foreign state that directly commits the act of terror. It will catch only the agent or proxy that carries out that act of terrorism on its behalf. And so the purpose of the legislation here is that in Clause 2, the bill be amended by replacing in line 26 on page 3 the following: a foreign state listed entity or other person. Again, the objective being to catch or to provide a civil remedy against the foreign state, which otherwise will remain immune if we go only after the act of terrorism committed by a listed entity in Canadian law. We agree that there should be a civil remedy with respect to an act of terrorism committed by that listed entity, i.e., as I said, Hamas, Hezbollah, etc. But we believe that the state sponsor of that listed entity, who may commit it not through its proxy, but itself, should be held liable as well. Otherwise, you're going to have a situation, Mr. Chairman, whereby the objective of this legislation can be defeated simply by the state carrying out the act of terrorism itself and not through its proxy or agent. And certainly that could not have been the intent of the legislator in this regard.
Mr. Harris?
Yes, we would support this amendment. Mr. Kotler is very knowledgeable in this area, and I believe we have some reservations about the efficacy of this legislation, whether it would actually be effective or whether it would perhaps raise expectations a little more than they realistically might provide. But if the purpose of this cause of action is to show that people are going to have a remedy for terrorist acts committed against them by states or by state-sponsored entities, then it seems logical to include the states themselves as actors in this. And so we support that. As you'll hear later on other clauses, we don't like the idea of having only listed states, but to include foreign states in this is proper, because if what we're aiming to do here is to give someone a remedy for terrorist acts, then including states in that is, in our view, considered logical.
Mr. Woodworth?
Thank you. Very briefly, I do respect the intention behind this amendment, but I have reservations about removing state-to-state issues from the executive level and placing them in the hands of the judiciary, which in effect this amendment would do. If charges are being brought in the courts, it in my view, is an inappropriate remedy for the ill that Mr. Kotler seeks to address. It is instead more appropriate for a government, taking into account the whole host of factors which may apply in the case of state relations to bring forward a remedy. Thank you.
Mr. Kotler?
Chairman, I have to say that I don't understand the submission just made by the honourable member. If what he seeks is to allow the victim to have a civil remedy, why would he wish to immunize the state sponsor who directly commits that act of terror from being held liable? It seems to me, somewhat absurd to say, okay, we will go after the proxy of that state sponsor of terrorism, but if the state itself commits the act, it's immune. That simply does not make any sense. This has nothing to do with judicial determination or executive act. This has to do with the whole question is, how do you provide an effective civil remedy for victims of terror? That's what this is all about. And you have a choice here. You either say that victim has a civil remedy only against the agent or proxy of the state committing the act of terror, or it has a remedy against the state itself when it directly commits the act of terror. Otherwise, you're going to have a situation here where it simply won't act through its proxies. It can be encouraged to commit the act of terror itself and then be immunized against any civil liability from the victim. So it just doesn't make sense. I don't understand, what the member is saying in terms of we support the bill. We want to make it effective. We want the victim to have a civil remedy. We don't want it to be immunized under the State Immunity Act. It takes away with one hand what it gives with the other. It just doesn't make sense from their point of view. Forget about me moving the amendment. This is something that the government should seek. This is something the government should propose, not something that I should have to come before this committee to do, because basically we want to support the legislation, but we want it to be effective. And we want that victim to be able to have a civil remedy against the state perpetrator directly. That's all.
Thank you. Seeing no other interveners, I will call the vote. Those in favor? Those opposed? The amendment fails. The next amendment is another one from Mr. Kotler.
Mr. Chairman, the government bill currently allows for a foreign state to be sued only if it provides support to a listed terrorist entity. But the bill should allow a foreign state to be sued for providing support to a terrorist group that is not a listed entity, provided that the listed entity is acting at the direction of or in non-listed entities, they're acting at the direction of or in association with a listed entity. Again, Mr. Chairman, the whole purpose of our amendment here is to actually make the legislation more effective. I would have thought that we would not have had to come here to do this, that the government would say, you know what, you have provided and made recommendations that in fact enhance our legislation, that allow us to make it more effective for the victim of terror. This is what this whole legislation is all about. And so, for greater clarity, this amendment will only allow a suit against a foreign state if it sponsors unlisted terrorist groups that are functionally connected to terrorist entities presently listed by Canada, but not if the foreign state sponsors terrorist groups that are unlisted and unaffiliated with those already on the Canadian list. So what we are saying here, Mr. Chairman, is basically that the rationale for this change is that terrorist organizations often function under other names. And so you have a situation where one name of the organization may be listed as a terrorist organization under Canadian law. Other aliases of that same terrorist organization may not yet be listed. This is a phenomenon that we know only too well, that the same terrorist agency, terrorist entity now listed just changes its name and it's no longer listed. But it still commits the terrorist act, and you still have the victim. But the victim will not have a remedy unless the amendment that we propose here will catch those who, in fact, then operate under an alias. Simply put, the amendment more fully enables the bill to meet its stated objectives. Again, not my stated objectives, which I share with the government, but its stated objectives with regard to this legislation. So the alleged sponsors being held liable for supporting terrorist entities that are satellites of already listed entities, thereby, in effect, closing a gap in the law that would allow listed entities to escape liability through the use, as I said, of an alias or through, let's say, outsourcing terrorism to other terrorist bodies. This is another way whereby they immunize themselves from the terrorism by simply outsourcing it or going under another name. The amendment does not alter the nature of the conduct for which the terrorist sponsor is being held accountable, nor does it permit civil liability for unlisted entities that are totally independent of listed ones. It simply removes a kind of ruse that is commonly used by terrorists and their supporters. Furthermore, and I close with this, Mr. Chairman, most unlisted entities, if they have committed a significant terrorist act, are likely to be listed by Canada eventually. Therefore, this proposed amendment, while effectively spreading a wider net in the pursuit of justice, also, in effect, seeks to implement the basic intent of the bill, and I'm saying this over again, Mr. Chairman. It seeks to more effectively implement the intent of the bill as proposed by the government, by allowing suits to be launched in a more timely way, rather than having victims wait for a prolonged listing process to run its course before being able to seek redress. It just means if they change their name, they go under an alias, but they are the same terrorist entity and are associated with the listed terrorist entity, then that ruse, by going under another name, will be caught by this amendment, and we will be able to, in fact, hold that outsourced entity also responsible because of its relationship with the listed entity. That's what it's all about, again, Mr. Chairman, only to make their legislation more effective.
Thank you, Mr. Cotler. Mr. Jean?
Yes, Mr. Chair. Just very briefly, I want to first of all thank the NDP for the 100 pages of amendments we received this morning for this bill. But with respect to Mr. Cotler, I understand what Mr. Cotler's issue is, but this is a state-to-state issue, and I would suggest, frankly, it violates the very principles of international law on his basis, because what he's suggesting is that judges would be able to decide what is a terrorist state or what is a terrorist entity, and I think that's more of a state-to-state issue from my perspective, and the principles of international law I think would be violated.
Mr. Chairman, Mr. Chairman, this is in fact seeking to implement the principles of international law. The whole question of international law is set forth in the whole notion of the State Immunity Act, shielding at this point, before any amendments, the government's remark, shielding state sponsors and their agents from any acts of civil remedy in Canadian courts. The government has agreed that we no longer want to immunize these state sponsors of terrorism or their listed entities. All I want to do is say, you're right, you've already done the international law thing. All we want to do is say, make it more effective. Once you've already agreed that the State Immunity Act should be amended so as to not shield state sponsors of terrorism, as to not shield either their aliases, their agents or proxies who go under another alias, then make it effective. What is the point of putting forth a legislation and bringing in an irrelevant notion about we don't want to give it to the courts? It has nothing to do with the courts, Mr. Chairman. It has to do with the fact that you want to go ahead and hold state sponsors of terrorism responsible or not. You already agreed. The government already agrees that a Canadian should have a civil remedy in the courts. have already agreed to give the courts jurisdiction. They've already agreed to give the courts jurisdiction in order to hold states responsible for acts of terrorism, in order to hold their proxies responsible. It's just not a matter of giving the courts jurisdiction that we want to give them jurisdiction that they wouldn't otherwise have. It's the same jurisdiction that the courts will have. It's the same liability that states will have. We want to make the legislation more effective. This parroting of some notion here that this is not in accordance with international law is simply incomprehensible, Mr. Chairman, with all due respect. It doesn't make sense. In accordance with what they are proposing, they should be supporting this amendment. I shouldn't have to be here today to argue for this amendment. I'm trying to make their legislation more effective. They really care about giving civil remedies to victims of terror, then they should want to make adopt an amendment that does that. Otherwise, what's the point of putting forth their own legislation? And to talk about international law courts and the like, the legislation is giving Canadian courts jurisdiction. This government legislation is giving Canadian courts jurisdiction. I'm not doing it by my amendment. The legislation does it. I don't think that the government understands the legislation that they themselves are proposing. Because if they understood the legislation they themselves are proposing, they wouldn't be making these comments here today. Because it just doesn't make sense, these comments.
Mr. Harris?
Thank you, Chair, and we support the amendment. And in response to Mr. Jean's concerns here, I don't understand where he's coming from. The clause that's being suggested being amended here already recognizes that the cause of action comes from a foreign state committing an act or omission that is, or had it been committed in Canada, would be punishable under the various sections of the Criminal Code. That's the definition of terrorism. What Mr. Kotler's amendment does is say that not just a foreign state or listed entity, it also includes a terrorist group acting at the direction or in association with such an entity. So we're talking about the ability of the cause of action to exist if it's done by a terrorist group that's not listed, but is actually acting in association with a listed entity or foreign state. How this gives judges powers to decide whether a foreign state is terrorist is beyond me. I think your comments may have relevance to some other part of the legislation, but surely when Mr. Kotler is saying, look, if we're going to be holding or giving people a cause of action if they're victims of terrorism, you have listed entities under the Criminal Code, you have foreign states, but then you also have groups that may not be listed but are acting in concert or under the direction of one of these listed entities or foreign states, then that also gives rise to a cause of action. I mean, there may be problems of proof. I don't, that goes back to our reservations about the efficacy of the legislation in terms of actually being effective. But in principle, if you're going to suggest that victims of terrorism in Canada have a cause of action within Canada based on these type of acts, then why would you not include non-listed terrorist groups that are acting in concert or at the direction of the same bodies? Now, you know, if the other side wants to object to that, I'd feel more comfortable with a reasoned objection rather than something that's misplaced or unbased. And hopefully, someone over there can, if they're not going to vote in favor of this, tell us why.
Mr. Woodward? I do object to the characterization of Mr. Jean's comments as unreasoned or not well placed. I think that up to this point in time that the Canadian government has, through Section 83.01 of the Criminal Code, provided a definition of a listed entity and to introduce a term such as terrorist group, which of course every one of us here knows what a terrorist group is, but I can tell you once you get into court without a definition of terrorist group, indeed that can be problematic. And I, for one, see nothing wrong with the approach of Canada up to this point in providing a list Thank you.
Honourable member, with all due respect, is confusing the question of the list of countries against whom an act can be taken. I have a separate amendment with regard to that. That is not what this amendment is all about. This amendment seeks to ensure that the agent or proxy of that listed state will not be able to escape civil liability by outsourcing it to under another alias. That's all we're saying. Is we're saying when you go into court, we want to make it effective. They agree that a Canadian citizen should have a civil remedy in a Canadian court. Up to now, that can't happen. This legislation allows it to happen. So it's not a question of the judicial determination. We agree that there should be a judicial determination. It is not a question of the listed entity and the government's making that determination as to who that is a listed entity as a state. I have some concern about that, but that's another point. I'm talking about now going on the government's own legislation with their own determination of the state as a listed entity, that the state proxy or agent should not escape liability by outsourcing it to another alias. That's all we're saying, making your legislation more effective. I have to say that I don't understand the objections of the government. My sense is the more I hear the objections, the more I feel they don't understand their own legislation that they are proposing and don't appreciate the fact that we're trying to make their legislation more effective and give Canadians a more effective remedy. They should, in fact, be responding to our amendments rather than voting it down. At the end of the day, they're going to have less effective legislation than they themselves wish for their own legislation, which we otherwise support in principle. And, Mr. Chairman, I have to tell you, this is an interesting case study of what's the problem with this whole approach. I say this because we have 9 bills like this. If we had disaggregated the bills, if we were able to give the proper time to each of the pieces of legislation, we might end up with adopting the legislation but getting better bills for the public, for the people of Canada, for protecting, and in this instance, Canadian victims of terror. And what we're going to get is a less effective version than what the government deserves to have and what the Canadian people deserve to have. And so at the end of the day, a Canadian citizen going into court will have a less effective remedy both against the state sponsor of terrorism. Now he can't take an action because they voted it down. My First Amendment. Not because it's my First Amendment. I thought it should have been in the legislation to begin with. Right now, a Canadian citizen who will have a domestic remedy in a Canadian court cannot take an action against the state perpetrator itself. And so if Iran tomorrow commits a terrorist act against a Canadian citizen, then the only way we can take an action against it is if Iran, in fact, delegated it or designated it a listed entity under Canadian law. That we agree. If a listed entity under Canadian law carries out the act, they should be held liable. But if the state carries out the act and doesn't delegate it or authorize a listed entity in Canada to do so, a Canadian citizen cannot now, under this legislation, take a direct remedy. That's been the result of them voting down the First Amendment. The result of them voting down the Second Amendment is that if a terrorist entity that is listed under Canadian law goes under a different alias, changes its name, is no longer a listed entity, the Canadian citizen will no longer have an action against them. Mr. Chairman, the result of the objection to these 2 amendments is to make their legislation ineffective. And so it'll be there, but it will not accomplish what the government itself seeks, Mr. Chairman. I find it surprising that they would not, be responsive to amendments which improve their legislation, improve the objectives of that legislation, provide protection for Canadian victims, provide them with an effective civil remedy, and neither immunize the state sponsor of terrorism, which is now immunized, nor immunize the alias or outsourced entity to whom the act is thereby committed, so they also get immunized. Regrettably, Mr. Chairman, the result of the rejection of 2 amendments is, number 1, a Canadian citizen will not be able to sue a state directly. Number 2, if the terrorist entity or proxy changes its name and is no longer a listed entity, even though it's functionally associated with the listed entity, they will not be able to sue that alias either. Mr. Chairman, this is going back to immunizing the very terrorist entities that this legislation was designed, in fact, to take their immunity away. It was designed to give effective remedies to Canadian citizens. We no longer will have effective remedies. That's the result of the rejection of the amendments, Mr. Chairman.
Thank you. Ms. Boivin?
Rapidement, Monsieur le Président, effectivement, quand je vois le genre...
When I see the amendments which are being proposed, the two that we have heard from Mr. Cutler, I'm concerned because when we are dealing with the measures in this bill, we don't have a great deal of hope. These measures should improve the situation and achieve the ends that the government wants to achieve. But the Conservatives are opposing and making ridicule of the amendments which are being proposed. And we have an omnibus bill here with 9 bills. We have fundamental legislation here, the Criminal Code, the Justice for Victims of Terrorism Act, the law dealing with certain controlled drugs and substances, State Immunity, Conditional Release Act, the Youth Criminal Justice Act, the Immigration and Refugee Protection Act, and other acts. So this is much longer than the number of amendments. I have... or I see, rather, that there seems to be a lack of understanding on the part of the Conservatives of their own legislation. They are proceeding wearing blinkers. It's not just a question of a play on words, because Mr. Cutler has explained very clearly the purpose of his amendments with a great deal of good, solid sense. But what happens? Well, we have these clauses. We have clauses which are ones which all parties are ready to approve. But can we do this in committee? For example, when we get on to the Youth Criminal Justice Act and the question of the sentencing.
People on the list, I'll now call the vote. Those in favor of Liberal Amendment number 2. Those opposed? Motion fails. Now, the next amendment is Liberal number 3, and I'm advised by the legislative clerks that if Liberal 3 is adopted, the Government 1 amendment cannot be go ahead because it's the same lines in the 2.
If the next motion is defeated, or
No, if the next motion is adopted,
yes,
then the Government 1 does not go ahead because
Thank
it's
you.
the same
thank you.
word.
Sorry.
Mr. Cutler?
Mr. Chairman, the purpose of this legislation has to do with the whole nature of Canadian law, the background with respect to the State Immunity Act and the jurisprudence that has evolved regarding notions of what it means for there to be a real and substantial connection for the victim to have a civil remedy. Since the State Immunity Act currently gives no immunity to states for damages which they cause in Canada, then cases against foreign states that will be brought under the government's proposed legislation will primarily involve acts outside of Canada, as I hope to indicate, for example, suing Iran directly, not just suing Islamic Jihad, which is sponsored by Iran, for killing a Canadian abroad. I might add, Mr. Chairman, parenthetically, you know, if you took the Lockerbie situation, it would not have been possible to go after Libya if the current wording in this legislation remains. That was why I proposed the legislation that you should be able to go after the state sponsor, Libya itself, for the Lockerbie terrorist act. What we have here, Mr. Chairman, I regret to say, and I will make this point once again so the government might reconsider, that what we see here is that the government is being, in effect, soft on terror and harder on the victims. This government, which purports to speak in the name of the victims, and we all want to protect victims, should be giving an effective civil remedy to those victims and not privileging the state sponsors of terrorism who commit terrorist acts against those victims. Now, the Iranian terrorist, the act of terror committed by the state of Iran, the Islamic Republic of Iran, or in the Libyan Lockerbie situation, they will be immune from a civil suit as a result of the government not wishing to respond to a remedy, an amendment that we proposed that would have given citizens a remedy. Now, with regard to this particular amendment here, what we want to do because under Section 4.2 of the present bill, for a victim who outside of Canada, who is victimized by a terrorist act outside of Canada, to sue in a Canadian court, he or she must establish a real and substantial connection to the jurisdiction in which he or she is launching the suit, i.e. here in Canada. And so the only connection to Canada will be the Canadian citizenship or permanent residency of the victim. But in recent court rulings, Mr. Chairman, it's likely that citizenship and permanent residency standing alone, and I think the government realizes, will not be sufficient to establish a real and substantial connection to Canada. Therefore, international law experts which we've consulted, and I suspect the same international law experts that they would be consulting, are of the view that it is possible that a significant number of actions against foreign states under this legislation may be precluded or stopped on jurisdictional grounds before they get to the merits, which would undermine the intention of the legislation. And there are cases now pending before the Supreme Court of Canada on this very point. Therefore, it's essential that the legislation explicitly state that a person's Canadian citizenship or permanent residency status is enough to establish a jurisdiction of the Canadian court. But the way it should be done is Section 4.2 that we are speaking of here, Mr. Chairman. We should be, in effect, deleting the 4 lines here and basically say, and I think this supports the amendment put forward by Mr. Gogan, the next amendment. I would just maybe word that for certainty, it is sufficient to establish that the plaintiff is a Canadian citizen or permanent resident within the meaning of subsection 2.1 of the Immigration and Refugee Protection Act in order to establish the jurisdiction of the Canadian court with respect to the cause of action referred to in this section. It's similar to what, in fact, Mr. Gogan is suggesting. The language I suggest to you may be somewhat more specific with regard to the same remedy and the same effectiveness that the government seeks. Again, Mr. Chairman, we are seeking only to make the legislation effective.
Thank you. Mr. Jean?
Yes, Mr. Chair. Just very briefly, my question to the honourable member is that he worked with the Minister of Justice, John Turner. He was the Minister of Justice from 2003 to 2006 as an Attorney General of the country. And if he's so adamant in supporting the government at this stage, why didn't he come up with the legislation when the Liberals were in power for 13, 14 years just recently. And I say that with respect, Mr. Chair, because he keeps saying the same thing, that he supports our legislation, he's trying to make it better, and yet it took a majority Conservative government to finally get it to this stage to get it passed. And bluntly, I have a lot of respect for the man. He was a great professor and an Order of Canada winner, and obviously Minister of Justice. But why are we here today and arguing about something that he wants to make better if he didn't do it in the first place?
Well,
Mr. Chairman, I'm delighted that he...
well, just a minute, Mr.
Yeah.
Cutler. I got Mr. Harris.
I'm sure Mr. Cutler can defend himself on that point. I will just say that time passes and ideas come, and sometimes they're ripe for consideration. I'm not even sure this one is ripe because I haven't been convinced of the effectiveness of this type of legislation, despite the enthusiasm which our witness from the United States brought to it. But clearly, Mr. Cotler has pointed out a significant gap in this legislation or hole, which the government has also recognized. Although I will say, Mr. Cotler, I'm not certain whether you are arguing now for your amendment to pass or to amend the amendment that the government has. And maybe you can clarify that, because it seems to me if the object is to ensure that plaintiffs at least aren't going to run afoul of a jurisdictional or forum nonconvenience type argument, that the way to do it is to be more particular, and perhaps the government's amendment, even with your add-on to it, would be more effective than the one that you now have before us, unless that's unless you're suggesting that your amendment needs another amendment to another section in order to be effective. I'm just there seems to be more than one way to do this, and you know, I'm interested in assisting to improve the legislation that is now before us, as opposed to some legislation that Mr. Jean thought might have been before somebody else at some other time in the past. So I believe we are here working together in good faith to try to improve this legislation, and I wonder, can you tell us whether or not you still wish to proceed in the manner you suggest by Liberal Amendment number 3, or would you be satisfied with the next amendment coming forward with some modifications?
Mr. Cotler?
Thank you, Mr. Chairman. I would be satisfied, because the legislation by the honourable member, in fact, does capture the amendment that is proposed by the parliamentary secretary, does capture the amendment that I had in mind, and I would be prepared and do support it. It's just a matter of the refinement of language. I do want to say, though, when I was asked why, just for the record, why as Minister of Justice I hadn't proposed similar legislation, Mr. Chairman, the answer was, if you look at Hansard, you will see that as Minister of Justice I sought to propose such legislation. We were defeated, Mr. Chairman. One of my first acts, and this can be confirmed, was the then Minister of Public Security at the time. I went to him and I said, we were defeated. This is what I was hoping to do, and I would hope that the Conservative government goes ahead and introduces this legislation. So I've been in support of this from the time that they took power. Way back in 2006, Mr. Chairman, because Hansard will show that I supported this in 2005. But we did not, at that point, get to the point where we had draft legislation prepared to go forward, although the intention to do so was clearly stated in the record. And I then proposed, and to Stockwell Day, the incoming Minister for Public Security, went to him and said, Stockwell, this is the legislation that we were intending to propose. We got defeated. I suggested you do it. We have a common cause here. We want to give victims of terror a civil remedy. So I just want to put that on the record, lest it be thought that we are coming up late to this idea and only seeking to do it now.
Butler, given the discussion that occurred with respect to your amendment and the government one, do you wish to withdraw your amendment, and we can move to the government one?
I will withdraw mine because, as I say, the government amendment captures what I had intended. My only thought is that maybe the language that I was proposing is somewhat finer, but I have no problem with because it captures the intent of what the parliamentary secretary is proposing.
Thank you, and I'll need unanimous consent for the withdrawal of the motion. Okay. So we'll move to the government amendment. Mr. Gauguin.
Yeah, just for the sake of clarity, what we're proposing is Clause 2 be amended by replacing line 4 on page 4 with the following: Canada or the plaintiff is a Canadian citizen or a permanent resident as defined in subsection 2.1 of the Immigration and Refugee Protection Act. And I'd like the public safety officials to comment on that briefly, if you'd give us leave to do that, Mr. Chair.
Certainly. Bill C-10, as originally introduced in Parliament, would allow any person to sue who can demonstrate a real and substantial connection between their action and Canada, and in a Canadian court. In Canada, the meaning of real and substantial connection has been established by the Supreme Court of Canada, which identified 8 factors to be considered when determining whether a court could be seized of a case that happened in another jurisdiction. According to these 8 factors, Canadian citizenship or permanent residency would not necessarily be enough to automatically establish a real and substantial connection between the cause of action and Canada. The proposed amendment would establish that Canadian citizenship or permanent residency of the plaintiff would be sufficient for a court to hear the case.
Not seeing anyone wishing to speak to it, I would call the vote. Those in favor of the government amendment? Opposed? It's carried. We now move to government amendment number 2. Mr. Gauguin.
Again, for the sake of clarity, Mr. Chair, Clause 2 amended, adding after line 4 on page 4 the following: subsection 2.1, in an action under subsection 1, the defendant is presumed to have committed the act or omission that resulted in the loss or damage to the plaintiff if the court finds that a listed entity caused or contributed to the loss or damage by committing an act or omission that is, or had it been committed in Canada, would be punishable under Part 2, Sub 1 of the Criminal Code, and b, the defendant, for the benefit or otherwise in relation to the listed entity referred to in paragraph A, committed an act or omission that is, or had it been committed in Canada, would be punishable under subsections 83.02 to 83.04 and 83.18 to 83.23 of the Criminal Code. And again, where this comes from public safety, I would ask leave for the person from public safety to comment on this, Mr. Chair. Thank you.
This amendment would lighten the burden of proof on victims of terrorism by creating a presumption of causation of damage. The amendment would establish that the defendant is presumed to be liable if it supported a listed entity that caused or contributed to the loss or damage subject to the cause of action. The presumption could be refuted if the defendant proved that he or she did not cause or contribute to the loss or damage in question.
Okay, thank you. I should have mentioned before we started the discussion here, if this amendment is passed, the legislative clerks indicate that Liberal Amendment 4 cannot be moved because it is similar in nature. So.
4 was withdrawn.
3 was withdrawn.
Great.
Okay, again, Mr. Chairman, that I support the amendment in principle because I support the legislation in principle, and this amendment, in fact, in the matter of liability, is relevant and helpful. The amendment that I was proposing, Mr. Chairman, and the rationale for it is because if a foreign state funds a terrorist body, because we didn't have explanation as to why this amendment was moved, and I just want to provide a background rationale for the government's own amendment. Let me say, Mr. Chairman, it's now just a choice whether it's theirs or mine, but the rationale remains the same. that if a foreign state funds a terrorist body which commits a terrorist act, it is usually very difficult, if not impossible, to prove that those specific funds caused a specific attack. In other words, it's difficult to establish causation, which is a necessary element for a successful suit against terror sponsors. Therefore, our approach was to put forth a deeming provision to be added that establishes that supporting a terrorist entity will make one liable for the terrorist attacks that that entity commits, even if it cannot be proved that a specific donated dollar brought about that specific bullet. That was the purpose for my amendment, which appears on the next page, Mr. Chairman. But I'm prepared to go along with one that goes along with the presumption and rather than have the deeming clause, because it captures the essence of what I think I would like to have. I think the deeming clause is preferable, but we don't have to go through the whole debate because it's not going to get accepted. So I'll go along with what the Parliamentary Secretary has proposed.
I don't want to go into much detail, or just to say that we support this amendment, because otherwise the record doesn't show in the votes that we actually support this particular amendment, and we support it for the reasons given by Mr. Kotler and Mr. Gauguin, I believe, as well.
Okay, seeing no other names on the list, I will call the vote. Those in favor of Government Amendment number 2? And opposed? Carried. Now, that precludes then the Liberal Amendment number 4. So that's all the amendments. Shall Clause 2 carry as amended? Those in favor? Carried. Clause 3. I have no amendments presented. Shall Clause 3 carry? Those in favor? Carried. Clause 4, I believe we have an amendment from Mr. Kotler, Liberal number 5.
Yes, Mr. Chairman, the legislation here is really, again, for purposes of making the legislation more effective by clarifying language in that regard. And so the amendment effectively reads that for purposes of this act, a foreign state engages in the support of terrorism if the foreign state knowingly or recklessly provides, directly or indirectly, material support to a listed entity as defined in subsection 83.011 of the Criminal Code, or to a terrorist group as defined in that subsection, acting on behalf of, at the direction of, or in association with a listed entity. And then the next paragraph, Mr. Chairman, seeks to define what material support is, so that we are clear what it in fact covers. Means currency or monetary instruments, financial securities, financial services, lodging, training, expert advice or assistance, safe houses, false documentation or identification, communications equipment, facilities, weapons, lethal substances, explosives, personnel, transportation, and all physical assets, but does not include medicine or religious materials. Again, Mr. Chairman, this is to both delineate and capture the nature and character of the terrorist acts so identified.
Thank you, Mr. Kotler. Seeing no other interveners, shall Liberal Amendment number 5 carry? Those in favor? And those opposed? Fails.
Mr. Chair?
Do we record votes?
We can do it.
Sorry, the vote was already completed. If you're going to ask for a recorded vote, do it before we...
Before we vote?
Yes.
All right.
So...
Mr. Gauguin is offering to have it recorded if you want. Just
I don't see why not.
Well, the clerk will do it if that's your wish. Sure.
Conservateurs d'un bord puis nous autres de l'autre.
Conservatives on one side and us on the other.
Madame Boivin.
Pour.
In favor.
Madame Borg. Mr. Cutler. Chairman.
Mr. Harris has requested a recorded vote, and the Conservatives have agreed to that after the vote was taken. So you
I
just
vote in favor.
Miss Finley.
Against.
Monsieur Gauguin.
Nay.
Mr. Jean. Mr. Radgiver.
Opposed.
Mr. Seaback.
Opposed.
Mr. Woodworth.
Thank you. So now, shall Clause 4 carried? Those in favor? Clause 4? Opposed? Carried. Now we have Liberal Amendment number 6 in Clause 5. Mr. Kotler?
Mr. Chairman, I have a series of amendments, as you can see, that hereafter follow. And let me just say that they all relate, in effect, to the same situation. And so you don't have to go through every one by one, because if they're going to vote it down, they'll vote it down as a whole. And let me explain it, because I suspect they will vote it down. So to try to save the committee time, I will explain the objective of the series of amendments that follow, because they're part of a package. And basically, Mr. Chairman, these amendments seek to remove the discretion of the government to list the state sponsors of terrorism, and to allow the victim of terror to make his or her determination as to which sponsor of terrorism they wish to sue. Regrettably, the legislation as it now stands limits the victim's suit to only those countries that the government will list as state sponsors of terrorism. Now, the problem we have, and it's the government's own witness, Victor Comras, this U.S. State Department official who appeared earlier when this bill was heard before the Senate, and then appeared again before us, said earlier and repeated again, don't go there. We did that in our American legislation, and the result was, by doing that, that in effect we ceded the right of the victim to the determination by the government as to who the victim could sue. And so the U.S. government, for example, listed 4 governments as state sponsors of terrorism. Now, if government 5 or 6 was not listed, but they committed a terrorist act, or their proxy committed a terrorist act, the victim in Canada would not be able to sue, because the government, for whatever reason, would not have put that government on the terrorist list. We believe that it's the victim that should be able to make that determination, not the government. Now, I know what the government may say, so I want to just conclude by saying the following. I know that the government has a legitimate concern with frivolous and vexatious suits that may be taken against our allies. Okay? So my amendment provides for that. What it says is that a civil remedy will not lie against a country with whom we have an extradition treaty, or government in respect of which a remedy will lie in that government's own domestic courts. In other words, United States, whatever. And so the purpose of the amendment is here, number 1, to broaden the number of state sponsors that the victim believes should be the object of a suit, but to guard against frivolous and vexatious suits by saying no suit will lie, against a country with whom we have an extradition treaty, that country be deemed to be one that protects the rule of law, has an independent judiciary, and the like. So we seek, through this series of amendments that followed, and that's why I don't have to take them one by one, because this is going to be defeated, then you can defeat them all at the same time. I just want to put forth what the objective is here. Give the victim of terror the option of determining against whom the suit will lie, rather than have the government arbitrarily determine against whom the suit will lie and arbitrarily limit the remedies that can be exercised. And again, the government's executive exercise of discretion is being preferred in the government's legislation to the victim's capacity to exercise his civil remedy with respect to acts of terror. Again, Mr. Chairman, it's somewhat anomalous, because we are here speaking for the victim and the effectiveness of the civil remedy. The government, and I take them at their word, they're seeking to protect the victim, but they're doing so in a way that will provide less effective protection for the victim. So I'm not questioning their legislative intent and not their motives. I'm saying that we both agree that the overall import of the legislation give an effective civil remedy to victims of terror. We are saying that the nature of the legislation as it now stands will unduly circumscribe that civil remedy by unnecessarily limiting the action that can be taken, by arbitrarily vesting in the government the discretion to choose against whom the civil remedy can be exercised, rather than vesting it in the victim with the caveat that it should lie only against states with whom we do not have an extradition treaty. Thank you, Mr. Chairman.
If you would just clarify, Mr. Kotler, you indicated that you were speaking to a number of your amendments. If you could clarify
I'm
to us.
referring really, Mr. Chairman, to the rest of my amendments. Oh, up to sorry, Mr. Chairman, to amendments
to 13.
It's referring to the amendment on page 5, the amendment on page 6.
Yes.
The amendment on page 7.
It seems to be 5, 6, and 7. Page 5 and 6.
5 and 6.
Yes. Lib 6, Lib 7, Lib 8, it seems to me, Mr. Chair.
The amendment, Liberal 7 and Liberal 8 amendments.
They're the only ones that refer to what he's talking about.
Those
6,
are,
7, and 8.
sorry?
Are you applying that to 6, 7, and 8? Your amendments?
Not numbered.
Yeah.
There's a confusion between Lib 6, Lib 7, and Lib 8, and page 6, page 7, page 8.
Something in that area.
Except that number 6 is page 5.
Six.
Specific amendments that fall under the question of the executive discretion in the delineation of the list of state sponsors would be those that appear in, it's on page 5, on page 6. Those are the two, Mr. Chairman. Sorry?
Lib 6, 7, and 8.
Yeah.
Okay.
Okay, thank you. So when we do vote, you agree that we'll apply the vote to the three of them, Mr. Kotler? That's,
Sorry,
we need the agreement that when we do vote, we're applying the vote to those three amendments?
those two, Mr. Chairman.
7, he's saying.
Yes.
Yeah, because that's clause 5.
Maybe I haven't shortened the time up at all, maybe I extended it.
Chair, just on a point of order, like those amendments are to different clauses, so it's kind of confusing procedurally. You know, I think his argument applies, but I prefer that we vote on the amendments separately, and then when we finish the proposed amendments to clause 5, we have a vote on clause 5, or because otherwise it's rather confusing, as we've just seen.
Okay.
Can I make a comment?
Well, I have Mr. Gauguin on the list first.
A detail to Mr. Kotler's comment. He was talking about the witness, Mr. Comrades, as being a government witness. He did testify, but in fact he was an opposition witness. Doesn't take away from his testimony.
Thank you. Mr. Harris?
If I may. You're correct.
Just a minute. I have Mr. Harris.
Okay, sorry.
Yeah, Mr. Kotler can clarify later, I'm sure. I think the point, though, I agree with the point that was made, and I do want to make a general statement about Clause 5 and about the whole notion of lists. So my comments might apply to some of these amendments as we get to different provisions. My comments are on Clause 5, and in the context of the amendment, I agree with Mr. Kotler that we should, if we're going to go down this road of saying we're going to open up a new tort, an international tort, this is something new, then we should do it properly. You know, a tort is basically a civil remedy for a wrong committed against an individual, and the legislation and the courts facilitate that by assisting in defining that and making it possible to bring these actions. But we've got a situation here where by creating a government-nominated list that's going to be changed every 2 years or reviewed 2 years as certain states against whom this remedy may apply, then I think we've got an anomaly contrary to the whole notion of creating a legal remedy for victims of terrorism. You know, the notion, the principle we agree with. We agree that individual victims of terrorism ought to have a remedy, and Canada can be a leader in doing this. There's not many other states do it. The experience of the U.S. was described to us. Whether it was a government witness or an opposition witness is irrelevant, but the experience of the U.S. is useful in that the one glaring example of the government removing states from the list is a case of Libya. You know, one of the cases that gave rise to this whole notion of having an internationally based tort for terrorist acts was the Lockerbie bombing, and clearly the Libyan government under Mr. Colonel Gaddafi was engaged in that. In fact, paid reparations at some point, but you know, here's a case where the government of the United States removed Libya from the list at a certain point. Well, if you know, if we're establishing a tort that's designed to have some not only effect on individual claimants, but also a general or normative effect, and maybe Professor Kotler can put on his law professor hat and recall back to the days of tort law. But one of the purposes of tort law is to change the behavior of people. You know, you can sue people for negligent driving, and that's and encourage them to drive properly, or at least to get insurance to insure against it, so it changes behavior. So if we're going to say that not only will states who sponsor terror be condemned internationally and other international actions, whether they be diplomatic or otherwise, that there will be an opportunity, at least in Canada, for people to pursue civil remedies against your country or your assets in other countries and curtail your ability to operate internationally by a consequence such as this. Well, then we should do it, and it shouldn't be interfered with by whatever diplomatic niceties might transpire. If we're going down this road, and I say we have our reservations about the effectiveness or about whether or not it will work, and that's one of the reasons why we proposed the motion at the beginning of this session today that there should be a review in 3 years, a comprehensive review of the effectiveness of this legislation, this being part of it, that we ought to say that this is a remedy that's available to Canadians who are victims of terrorism, supported by entities or states, that's open-ended, and it should not be interfered with. I don't think we need to go much further than that, and we saw how Canada and previous governments of Canada had different types of relationships, again with the country of Libya over the last couple of decades. There were times when they were shunned. There were other times when they were frankly embraced. The government, and I probably literally and figuratively, despite the fact that this country was engaged through its leadership in support for international acts of terrorism. So if there's going to be a remedy here, I think the remedy ought to be against any states whose governments actively engage in the support of terrorism, and we shouldn't leave them immune for this. This is going to be an exception to the State Immunity Act. Then it should be an exception that's available in a broad way. This amendment goes some way to ameliorating the lists. And so we would support this amendment, but I will say, and I'll save myself a second speech, when it comes to the vote on clause number 5, we will oppose that clause, and we will oppose the clauses that engaged in clauses 6, 7, and 8. Sorry, 6 and 7. I don't want to get mixed up here. Clauses 6 and 7, which also deal with the list issue. So we are opposed to this idea of having only lists that can be changed from time to time. We think that if we're going down the road of creating an international tort for terrorist acts committed by states or sponsored agencies, then that should be open-ended and not dependent upon the whims of Canada's foreign policy at any particular time. It seems to me that if victims of terrorism are to be given a remedy, then they ought to be given a remedy through our courts and through our legal system, and we should ensure that that's available to anyone who's unfortunately in that circumstance. The aim here, obviously, is to not only provide a civil remedy, but also to deter states from engaging in that as part of one of the consequences of providing for civil suits. So we will support this amendment and the others, but we will not support Clause 5 as a whole, because Clause 5 is the clause that sets up and supports and provides provisions that relates to the idea of only listed entities having being able to be defendants in actions.
Thank you, Mr. Harris. I have Mr. Woodward.
Thank you very much, Mr. Chair. I am not certain whether or not I heard Mr. Kotler suggest that decisions to list or not list an organization would be made arbitrarily or on the basis of unnecessary considerations. I hope I didn't hear him say that, but I just want to make it clear that if anyone did feel that our government or any Canadian government's decision to list or not list would be made arbitrarily or unnecessarily, I would take issue with that. I also want to say that I am no expert in this, I acknowledge, but it seems to me that decisions to list or not list an organization as terrorist may engage interests other than simply the interests of compensation to victims. I will give a negative example that I am aware of, and that is a decision which may need to be addressed to delist the MEK, which is an Iranian terrorist group currently resident in Camp Ashraf in Iraq. And I have constituents who very much would not want the government to delist that group until that group gave transparent access to the residents of Camp Ashraf. That may have nothing to do with compensation or indeed even to terrorism, but it is a valid interest that I would hope a government would be able to take into account in making such decisions. So I just want to make the point that I don't think listing or delisting decisions are made arbitrarily or unnecessarily, but they may be made on the basis of other interests than only the interests of compensating victims, which I recognize are important, simply not necessarily the only factor. Thank you.
Thank you. Having no other interveners on our list, I would call the vote on Liberal Amendment number 6.
Record this, please.
Recorded vote, clerk.
Mr. Harris,
In favor?
Madame Boivin,
En faveur.
En faveur.
Monsieur Jacob,
En faveur.
Madame Borg,
En faveur.
Mr. Cutler,
En faveur.
Ms. Finley,
Against.
Monsieur Gauguin, Mr. Jean, Mr. Radgiver,
Opposed.
Mr. Seaback,
Opposed.
Mr. Woodworth,
Motion fails. So we're now at Liberal Amendment number 7. Mr. Kotler, I don't know, did you wish to speak to this or?
Mr. Speaker, the reference here refers to Clause 6 of this legislation, and the amendment seeks to replace lines 39 to 42 on page 6 of the legislation with the following.
If you will, just a second. We're at your amendment number 7.
So he can just not move it.
It may very well be, and we had some confusion a few minutes ago probably that I created, but if you don't wish to discuss it any further, you consider you have, we can vote on it now.
You're referring now to
Number 7?
number 7, correct?
Yes.
Mr. Chairman, this proceeds it states here that Clause 5 be amended by adding after line 35 on page 6 the following, that if a court of competent jurisdiction, and again, we are vesting jurisdiction in the courts by reason of this legislation, if a court of competent jurisdiction has determined that a foreign state that is set out on the list referred to in subsection 2 has supported terrorism, and that is the list as drawn up by the government. I might just say parenthetically to the query that the parliamentary secretary was saying, I don't impute to the government any sense of arbitrariness in the setting of that list. I'm worried about the consequences of that list, namely the consequences that would limit the civil remedy. I don't question the government's good faith. I question only the effectiveness, and that has been the purport of all my amendments here. So to continue here, is set on the list referred to in subsection 2 as supported terror. That foreign state is not immune from the jurisdiction of a court in any proceedings against it that relate to terrorist activity by the state as defined in subsection 83.1 of the Criminal Code on or after January 1st, 1985. I think it speaks for itself.
Okay, thank you. Having no other interveners, we'll call the vote. Shall Liberal Amendment 7 carry? Those in favor? Those opposed? Fails?
Note for the record that the government is voting against the remedy to be taken against the list they propose. In other words, once again, defeating the effectiveness of their own proposed amendment. This is a very set of anomalous situations, Mr. Chairman. We are seeking to give the victims more effective remedies while supporting the legislation.
I think if you wish, Mr. Cotler, you could ask for a recorded vote.
Yes, I do ask for a recorded vote on this.
Well, we already took the
No,
vote.
we
I'm
already
sorry.
took the vote, and
Okay.
this is further debate on a matter that's already been voted on.
Fine.
We're now at shall Clause 5 carry? Absolutely. Shall Clause 5 carry? Those in favor?
Mr. Harris? Madame Boivin?
On est sur l'amendement de Monsieur.
On the amendment?
Well,
My vote is to oppose Clause 5.
okay. Madame Boivin?
Je suis contre la clause 5.
I'm opposed.
Madame Borg?
Contre.
Mr. Cotler?
I will abstain on it, Mr. Chair.
Okay. Ms. Finley?
For.
Monsieur Gauguin?
For.
Mr. Jean?
For.
Mr. Radgibber?
Yay.
Mr. Seaback?
In favor.
Mr. Woodworth?
In favor.
The Clause 5 carries. We now move to Liberal Amendment.
Just a point of order, Mr. Chair, if I may.
Sure.
I just wanted to point out for the record, Mr. Chair, we have 208 clauses. We've dealt with 5 clauses in almost 2 hours. By my recollection, it's going to take about 40 meetings to get this through. The House has specifically directed this committee to deal with this matter within 100 days of sitting, and I think Canadians have had enough, or thereabouts. I know we have received direction. But the point is, Mr. Chair, is if we're going to sit for 40 meetings to get through these clauses, and I understand they're very important, but we've debated and debated this. We've debated it at previous parliaments. We've dealt with this matter intensely. So I just want all members to recognize that this is going to take 20 meetings to continue, which means 10 consecutive weeks. We will not have this matter done until March or April. So, you know, I would just like to direct all members' attentions to that.
Point of order, Mr. Chair. I realize that your mathematics may be correct if we're looking at the first 5 clauses, but I just will point out that when we get to Clause 10, I have a motion to, in fact, pass 25 clauses in one vote, if the committee so wishes. So, if we applied that logic to it, we should be finished by noon. So I think that is very early in the game to be suggesting how many days or hours or years it's going to take to go through clause by clause, and we haven't been sitting for 100 days since May the 2nd, or since May the 2nd. So there's lots of time to give this due and proper consideration. We have a job to do here on both sides of this table, and I, for one, and our members here intend to proceed to do that. If the government doesn't want to have proper consideration for this, then they can move a motion of closure as they did in the House, but we would oppose that strongly.
Thank you. I appreciate the interventions, but obviously the time in clause by clause is always the time it takes, and we'll try and move along as quickly as we can, but it is the nature. Mr. Cotler?
Mr. Chairman, I just want to say that this first bill we have supported in principle. Number one. Number two, this is precedent-setting legislation. And maybe the government doesn't realize the importance of the own legislation that they are themselves proposing. And so I find it passing strange that they would object to the kind of consideration we are giving to precedent-setting legislation, which purports for the first time in Canadian legal history to amend the State Immunity Act to give a civil remedy to victims of terror. Now, that deserves, and the Canadian public, I think, would wish that this committee give it the informed consideration that it warrants. And I might add, Mr. Chairman, it has not been considered by this House before. It has been considered in the Senate. It has not been considered by this House before, and the amendments so proposed for the first time in this chamber, and the amendments that I've been proposing here today, are designed to improve the legislation for the purposes that they seek to have enacted.
Thank you. Ms. Boivin?
Brièvement, effectivement, c'est un projet.
Yes, this part of the bill has not been reviewed clause by clause before, and I'm not suggesting that anyone is trying to kidnap the debate in any way whatsoever, to hijack the debate. I think we are proceeding with all intellectual honesty, certainly on this side of the table. And I really don't appreciate this mathematical attempt or reference to dealing with these clauses. It's going to take the time that it takes. We have to know that we have taken the necessary measures, and if my colleague across the way thinks that someone is trying to avoid moving ahead, no. I think our discussions are very important, and this really must be well considered by the committee.
Clause 6 and the Liberal Amendment number 8. Mr. Kotler.
Thank you, Mr. Chairman. As the amendment reads, that Clause 6 be amended by replacing the lines 39 to 42 on page 6 with the following, Mr. Chairman, the following words, and that is that an agency of a foreign state or in respect of proceedings that relate to a terrorist activity or the support of terrorism engaged in by a foreign state. Again, Mr. Chairman, the purpose of this amendment is to seek to clarify and make more effective the remedy for the victim of terror against the foreign state, its sponsors and agencies in that regard.
Thank you, Mr. Kotler. Seeing no further interveners, call the vote on Liberal Amendment number 8. Those in favor? Those opposed? The amendment fails. So, shall Clause 6 carry? Those in favor?
No. Can I comment on Clause 6? We'd be opposing Clause 6 for the reasons stated, because it incorporates the list of countries. The same would be applied to Clause 7 and Clause 9, so I don't need to repeat that. But without the necessity of a recorded vote, I just want to let the record show that we're opposed to Clause 6, 7, and 9 because of the reference to the list in those clauses. We will support Clause 8.
Okay. So shall Clause 6 carry? Those in favor? Those opposed? Carried. We're at Clause 7 and the Liberal Amendment number 9. Mr. Kotler.
Yes, Mr. Chairman. As it reads, that Clause 7 be amended by replacing lines 2 to 5 on page 7 with the following: used for commercial activity, terrorist activity, or the support of terrorism. Again, Mr. Chairman, for the purposes of making the civil remedy more effective and for ensuring that the state sponsor of terrorism and their agencies are more effectively held liable, and to seek to implement the overall nature and purpose of this legislation on behalf of the victims of terror.
Okay. Mr. Harris.
Yeah, we would support that, that amendment. That actually effectively removes the list and replaces it with, removes the list of foreign states, but provides that equipment used, property used for commercial activity, terrorist activity or support of terrorism would be subject to that particular section.
Seeing no other interveners, we'll call the vote on Liberal Amendment number 9. Those in favor? And those opposed? It's a tie. Motion fails.
Yep.
Yeah, he didn't vote.
Mr. Chair?
I'm
Point of
sorry?
order. I don't know if it was my vote that wasn't counted to that, but I raised my hand, I put it down for the favor.
Did you
but
see it? I honestly, I didn't see it. The clerk didn't see it. Please keep your hand up if you're intending
I'm sorry,
to
Mr.
vote.
Chair, we're moving close, but certainly if that's the condition, was it my vote that was not counted?
So the amendment fails. And I would call the vote on Clause 7. Do we have a Liberal amendment? On top of the page, I didn't see it. Liberal amendment number 10.
Chairman, again, referring to Clause 7, that it be amended by replacing the lines 13 to 16 on page 7 with the following words: rendered in any proceedings that relate to terrorist activity or the support of terrorism. Again, the purpose of the amendment for the purposes of rendering more effective the civil remedy involved.
Thank you, Mr. Kotler. Butler, I understand that there is a discrepancy between the English and the French.
That is correct, Mr. Chairman. I understand that there is a discrepancy between the English and the French.
So you were moving the English amendment?
Yes, Mr. Chairman.
Thank you. Those in favor of the amendment? Of the English version of the amendment.
Okay.
Those in favor? And those opposed? We got it. Thank you. So it fails. So now we're at, shall Clause 7 carry? Those in favor? And those opposed? Clause 7 is carried, and the committee is now out of time. This meeting is adjourned.